Every estate plan has three critical elements, and one is either a will or trust, one is a financial power of attorney, and the other are healthcare powers of attorney. Those are the three essentials. So a healthcare power of attorney is where you name people who can make medical decisions for you if you are incapacitated and unable to verbalize your decisions or unable to make decisions for yourself. And in that healthcare, we call them healthcare advanced directives, and that includes like a living will for decisions to be made at the end of your life, a mental health power of attorney in case you develop a mental health disease, but you're giving your designated agents instructions on this. These are the decisions I want you to make. These are my values. This is what I believe in. If I'm not able to make these decisions, I want you to make these decisions for me. When you don't have those in place, oftentimes we'll find that family members will have to go to court and get guardianship in order to be able to make some of these tough decisions. Or we'll have family conflict because no one's in charge of making decisions. The family will gather at the hospital, and half the family wants one action, half wants the other, and now they're fighting. And so having these documents, again, so much of this is about maintaining family unity and making sure that your wishes are always carried out. The other document is the financial and personal power of attorney. And this is a document that in which you name people who will make financial and personal decisions for you in the event of your incapacity. If you have a stroke or a head injury or any other situation in which you're not able to manage your financial affairs or personal affairs anymore, you name people that you trust to do that, and they have a fiduciary duty to carry out your wishes. Again, very important decisions. We have a lot of families who assume that they should name their oldest son to be their financial power of attorney agent. Their oldest daughter should make all their healthcare decisions. And so we work with families to help them understand that that's not always the best decision. It's not about protecting your child's feelings. It's about ensuring that someone you trust implicitly is going to carry out your wishes. So those are the three, if you will, legs of the stool, having a will or a trust, a financial and personal power of attorney, and a healthcare directive, healthcare power of attorney. In addition to that, we talked about if you are a family with small children, we have what's called our Kids Protection Plan. And in that we do guardianship nominations in the event that the parents are incapacitated or die before that child reaches the age of 18. We do short-term custodial appointments. So, kind of take that scenario I talked about earlier, where mom and dad are out at a date and their child is home with a babysitter, and mom and dad don't come home that night. We help the family identify what we call first responders that can be at that child's site within 20 minutes with proper documentation to show law enforcement or the Department of Child Safety representatives that I have been given legal authority by the parents of this child to take them into my custody in the event that they are not available. And the whole idea here is you make sure that child never ends up in the home or care of strangers, that they're always in the care of people that know and love them and will care for them and comfort them and make sure that they're safe and properly cared for during that time. So yeah, we got those, and then as like I said before, as we start moving into our older years and the possibility of long-term care or skilled nursing care comes into play, we had a whole nother set of planning and documents that we do to ensure that that's properly paid for without draining your life savings.
Okay. So, with your experience in this field, how often has a situation arisen to where somebody had a default? And what I mean by that is, they didn't have these things in place, and it defaulted, as you were saying, maybe to the oldest son or the oldest daughter, and they were reacting in an emotional way instead of in the way that maybe would have been congruent with the wishes of, let's say, the person who is maybe incapacitated or have some kind of issues, mental issues, or whatever the case may be. How often have you noticed that it has defaulted to somebody who is not really the individual that you would want to have take care of some serious matters,
Mhm.
and it kind of hasn't worked out the right way.
Well, fortunately, I don't run into that very often because my mission in life is to get out and educate people about this and make sure that they get this planning in place. And so the people that come to my office, very often they come because they've heard me speak and they are coming to get those plans in place. But let me tell you a story. It's not my personal story, but it was back, I guess about 10 years ago, a family traveling through Arizona. They were from California. um, they were involved in an accident. Mom and dad were both killed, and they had three small boys who survived the accident.
Wow.
And so the mom had two sisters, and these sisters were fighting over the custody of these children. And unfortunately, a lot of times these family disputes arise not because they are so keen to take on three kids that they didn't birth, but because often there's a lot of life insurance and other financial assets tied to the children. And so we'll see families fight for custody and control of the kids because that gives them access to the funds as well. And that's very unfortunate, but we see it happen. And so these two sisters are fighting over the custody and guardianship of these boys. Um, that legal battle lasted over a year. Over $100,000 was spent, and all that money came from those boys' inheritance from their parents. You know,
Wow.
the sisters are not paying for it. It came out of those boys' assets that they inherited.
Wow.
And so all these legal bills and all this conflict, and the boys are being, they go live with grandma and grandpa for a while, and then they have to go live somewhere else, and then they're seeing all this fighting.
Wow.
So that is actually, unfortunately, not that uncommon. I just read another story. It happened just a few years ago, the exact same thing, where a dad was divorced from the boy's mom. She had severe drug abuse and mental issues, and dad and son were traveling through Arizona, got involved in an accident. Dad got killed. So now the question rises, does mom get custody of this child when she has so many problems of her own?
Wow.
She's a biological parent, but she's got, some mental issues, and she's got some substance abuse issues. And if not her, who? And so again, this child was actually critically injured. He was in the hospital for a while in the ICU. And this is one of the cases actually where the Department of Child Safety came in and did a really good job of making sure that child was properly cared for and finding appropriate people. But they had to go through this process of eliminating mom as not being suitable, and then going out and reaching out to the family and figuring out, who would be willing to come in and take this child into their home and raise them for the rest of his life. But the, the the key to that story is that mom and dad had no say so in who that person was.
Wow.
So they don't know, that child may be raised by someone who has spiritual values that are in direct conflict with theirs, or
Right. Right.
social values, and so that child's being raised by someone who's going to, provide them a home, but that child may not be raised the way those parents would have wanted.
Wow. Okay. Yeah. That makes a lot of sense. Thank you for clearing that up for us. And so, one of the questions we have is, does a living trust avoid estate tax? Help you or help one to avoid estate tax?
Sure. So the person who creates the trust during their life does not get any tax protection during their life. They don't
Mhm.
get any creditor protection during their life. So the courts have made it very clear that if you owe taxes during life, the IRS can take them right out of that trust. If you have creditor issues, bankruptcy, the courts can go in right into that trust and take those assets. However, through a living trust, there are options that we can design into it that allow for, at the death of the first of the couple to die, assets can go into a tax bypass trust, a tax avoidance trust, so that the surviving spouse gets full access and use of all of the funds without having to pay estate taxes at that time.
Mm.
And then there's actually even a mechanism where we can pass those assets down to the future generations and still avoid a lot of those estate taxes. So there's definitely, if you're in a taxable range. Now, as of today, the federal estate tax exemption rate is like $12.4 million, somewhere in that range. We have a few clients who that applies to, that we're able to help. We have, the majority of our clients are sitting in the air somewhere between, $500,000 to $3 or $4 million, and the federal estate tax exemption rate is not going to hurt them. At their first death, those assets can pass to the surviving spouse with no estate taxes. However, the current exemption rate of $12.4 million sunsets in 2025, and it will go back to its pre-Trump rate, because President Trump, when he was in, he's the one that raised it up, basically doubled it from where it was before. So when that exemption rate sunsets, it will go down to about $6 million. And that actually is going to impact a lot of people who are sitting in that 6 to 8, $10 million range. And so we can take and shelter anything that those estate taxes would be due on in a special trust, that again, the survivor has control over and access to the funds, but doesn't have to pay the estate taxes, and then pass them on to the future generations as well, with estate tax savings for them. Estate taxes are nothing, they're almost 50%. So, if you're sitting, if this exemption rate is $6 million and you're sitting on an $8 million, estate at the first death, you're looking at $800,000 in estate taxes. And so, yes, it's definitely worth it to consider looking at mechanisms to be able to shelter some of that under the IRS rules. It's all above board. The IRS totally recognizes it and has approved it.
So with that sunset date that you just mentioned, does anybody who gets their trust or these things in place before that sunset date, are they grandfathered in, or does it revert back to everybody, for everybody?
Yeah, it reverts to everybody. So if we have a client, for example, right now that has an $8 million estate, and today they're not affected, and if one of those partners dies before that sunset date, everything's fine. But if they die January 3rd, after that sunset date, then that spouse is going to be hit with those estate taxes.
Wow. Okay. All right. Next question. What criteria do you consider when recommending a trust versus a last will and testament?
I love this question. You know, there are a lot of estate planners out there who have these arbitrary numbers. If you have more than $400,000, $500,000 in liquid assets, you need a trust. Or and we see a lot of trust companies that are really more investment firms that create trust for people than actual planners. And they'll have these arbitrary numerical designations, like, well, you need a trust because your estate's worth X amount of money. My criteria is I sit down and talk with the family. I look at their family dynamics and we get their story. And I love getting the family story, because when the family tells me their story and I'm able to dig into it and really understand what's going on with their children, what's going on with their siblings, and what their financial status is, and all of that, I can help guide them to make the right decision, regardless of the value of their estate. If it really boils down to this, if the client believes that their estate is going to have to go through the probate process and they don't want it, then they need a trust. That's one criteria. Now, there are some, some clients. I had a client come to me one day and say, "John, I want a trust." And I said, "Okay, let's sit down and talk about it." This person was living on about $1,100 a month in Social Security. She had a rented apartment and a 15-year-old car. And I said, look, I understand you want to trust. Your neighbor has a trust. Your neighbor told you needed a trust. I can't in good conscience, do that for you, and have you invest your money into a trust. And she definitely did not qualify in my mind for that. So, but that's kind of the exception. We do have, I got a client right now who owns a home. The home is paid for, doesn't really have any other assets, but is adamant that when he dies, he does not want that home to go through probate before it goes down to his kids. And so, we talked about it, and he agreed that the trust was the best way to do that, because the trust completely bypasses probate. There is no court involvement at all. And that's what he wanted. And so he was willing to invest a little bit more in getting a trust plan done, even though, he has no cash assets to speak of. His daughter actually paid for the trust for him. And so, it really comes down to what the client values and what they want for their children. Because in the end, an estate plan, I should say a will or a trust adds no value to you today other than peace of mind. It adds value to your children and your heirs in deciding, do they go through that probate process, or do we pass all our assets to them outside of the probate process, free of the courts? Just to kind of give you a quick example of that, and it's still answering the question about criteria.
Yeah.
But this is what I ask people. Probate is public. It happens in civil court. Civil court records are public records. Anyone can go in there and see exactly what you left your children, how old your children are, the value of your assets. It's time consuming. Probate, in a best case scenario, we can get through probate in 12 months on a very simple estate. More often than not, we're looking at 18 to 24 months. As we try to get assets liquidated and appraised and all of those things. It's expensive. On average, we see a probate, when you calculate in attorney's fees and appraisals, court costs, things like that, anywhere between $35 to $100 to $5,000 to go through the probate process. And like I said before, there's that inherent conflict that can arise in the family when people start, having to go to court and look at these things. So in a trust, all of that goes away. It's private. Assets pass to your children, to your other beneficiaries, to heirs, whoever you name, completely privately. No one gets to know unless the beneficiaries share. It's extremely low cost at the time of death. Basically, there's an affidavit that a new trustee has to fill out. So we're talking a few $100s versus thousands of dollars at the time of death. And it avoids the family conflict, because you've laid out in your trust all of your instructions for what you want to happen with your assets, where you want them to go, and there's so much flexibility in that. And so those are the criteria that I present to the clients and say, if you're okay with the probate process, you're okay with the publicity, with the cost at that time and the time, and these other things are not important to you, then that's fine. I'm happy to do a will for you. But if these things are important to you and you want to avoid that for your family, then the trust would be the answer. And so the criteria for me is really what the client tells me is important to them.
Okay.